Can I be held liable for unintentionally infringing on someone's copyright?
People still complain that their works are being sampled. Some say there's copyright infringement. Is it that the laws are not working, or just that the laws are being too flexible?
If I know my sound will get muted, can I go ahead and just use the visuals?
Once you accept that you are uploading your songs under Creative Commons, then it means you waive your economic rights over it.
If I want to critique someone's work, like let's say a film, a song, and I want to critique it, am I allowed to use like just a little bit of it?
Hello, welcome to Bnoskka IP Zone, and today it's our 16th episode, and we want to look at copyright and other related offenses. So that is what we will do. And before we venture into today's topic, I want you to subscribe, share, like this video, and make sure that other people also get to hear of it so that it benefits all of us. And of course, it is Apprise music production, and we do publication of musical works and also distribution onto all digital platforms. And you cannot just waste your time. Come on, and we'll get the best deal. We'll make sure that even if you don't have a music video, it can give you a music video. And it's a very little fee, or like the way you can contact other people, give you big budget for that. We will just do that for you. And so let me look at those in-house studio and their names and where they have come from. Let me start with you. What's your name?
Hi everyone, my name is Phillip Neewhang. I'm a content creator, a musical artist, and I work here with Apprise Music.
Right, and your name too?
My name is Samuel. I'm a student.
All right, so welcome Philip and Samuel to Bnoskka IP. So today is our 16th episode, and basically we are trying to look at copyright and related right offenses. Now, when we say copyright and related right offenses, first let's look at a person. So a person who reproduces, duplicate, extract, imitate, import into the country, except for that person's personal use, any work, is an offense. If you want to duplicate somebody's work without the person's authorization, or reproduce, or extract, or imitate, and you don't have the person's right, okay, it means it's an offense. Now, if another person causes to be reproduced, duplicate, extract, imitated, or imported into the country, except for the person's personal private use of any work, it is also an offense. Like you ask somebody, oh, go and copy this song for me. Go and copy this. Go and photocopy this. Then you are selling because you are not the one who photocopy. You cause somebody to make photocopies of people's works and you are selling. It is an offense. Distribute or permit or causes to be distributed in the country by way of sale or otherwise any other work. It is also an offense. You are making photocopy and you are giving it to people to be selling on your behalf when you don't have the right and you're not the right owner. It is also an offense. Remove or alters any electronic rights management information, distribute, import for distribution, broadcast, communicate, or makes available to the public works, performances, copies of fixed performances or sound recordings, knowing that electronic rights management information has been removed or altered without authority. So it means you pick people's things and you remove their names and then you sell it so that they will not know that this work is from Clement or this work is from Samuel or this work is from Philip. Okay, once you do that, it's an infringement. Or you circumvent any technological production measures applied by right holder to the protected work. Like you try to fix something in it. Okay, once you do all these things, it is an infringement. If you cause any person rent or lend to the public of any work, you lend, you go and buy it, and all you do is you are sharing it, it's an infringement. Or you perform it to the public when you don't have the right, it is an infringement. Where the person performing the act knew or had reasonable grounds to know that the action induces or enables or facilitates or conceals an infringement of any of copyright or related rights protected under this act without the license or authorization of the person whose rights are protected under this act, the agent of that person whose rights are protected infringes the protected rights and commits an offense punishable under this act. You see, so if you do any of these things, you'll be punished by law. So let's look at some of the penalties for copyright offenses. A person who infringes a right protected under this act commits an offense and is liable on summary conviction to a fine of not more than 1,000 penalty units and not less than 500 penalty units, or to a term of imprisonment of not more than 3 years, or to both. And in the case of continuing offenses, to a further fine of not less than 25 penalty units and not more than 100 penalty units for each day during which the offense continues. So you have been notified that don't do this. Don't copy songs of people's pen drive. Don't buy pen drives and copy people's songs and be standing in traffic light and be selling it. It's an offense. And then you have been notified, stop. You can be fined up to 1,000 penalty units, or you can go to prison. Both, you pay the fine and still go to prison. Okay? And if you continue to do the same thing, then it means 100 penalty units for every day the offense continues. Okay? So those of you who stand at traffic light, you are not selling your own song, like we saw in the video where one singer actually took his own songs and be selling at stations. That was right. But if it's not your own, you can't do that. You can't do that. Now, offenses by a body of person. This means a copy or group of person. Where an offense is committed by a body of persons under this act, in case of a body corporate other than a partnership, every director or secretary of the body corporate shall also be deemed to have committed the offense. And in the case of partnership, every partner shall also be deemed to have committed the offense. So let's say a company, you go and use somebody's work for your advert and you don't have right to buy it and you are sued. Every director of the company is deemed to have committed the offense. Okay? Or if it's a partnership company, then every partner involved in that company is also deemed to have committed the offense. Now, let's look at compensations to victims of offenses and forfeiture. In addition to any punishment imposed by the court in respect of any offense under this act, the court may, that the sum of money arising out of the offense be paid to the person entitled under this act to those sum, and that the reproduction, duplication, extract, imitation, and other materials involved in the infringement and the implements or devices used in the infringement but forfeited and deposited as the court may direct, having regard to the circumstance relating to the infringement. So everything, any person that is found to be doing these things, they can direct that all those equipment, everything should be deposited at the court, and you will pay a sum fine of money. Now let's look at civil remedies and how does the law address it. Civil remedies here means that you can take an injunction to prevent the infringement or prohibit the continuation of the infringement, or prohibit the importation of goods or goods ready for export for an order requiring the customs exercise and preventive services to detain the goods. So you can go to court and ask that SEPS should intercept your music video which has been put on CDs and they are selling it abroad and you don't have any knowledge about it, or your songs have been downloaded into people's pen drives and they are taking it abroad, playing it to go and sell. You can contact SEPS office to be able to intercept that so that the offense cannot be perpetrated. the recovery of damages for the infringement. So here you can file in court and say that because of this person's doing, I have lost so much money. So therefore, the court should award me 500,000 Ghana cedis or 200,000 Ghana cedis or 1 million. We all heard when Bamfo sued Drake in US, right? Yeah. For what? $5 million. Because he thinks that the offense has deprived him of getting money. And so therefore, he needs to recover these damages for the infringement. And then also, you can also go to court to ask for the grant of an injunction that's to prevent the person from ever engaging in such an activity. So this is some of the infringement. Now, let's see how, when this infringement comes, what can be done to be able to protect your right. One, the law says that any dispute arises between any parties under this act or in relation to the copyright or claim under this act, the parties involved in the dispute may seek to negotiate a settlement of the dispute at the Copyright Office, where negotiation under this section may be made by the either parties or both parties to the copyright administrator, who shall mediate for a settlement. So if you can go to court straight, or you can go to the Copyright Office, and here means when you go to the Copyright Office, you will have to pay money for you to have your case heard. And so therefore, by this Copyright Act, it has also established what we call Copyright Tribunal, which is a court which you can go there to deal with your case quickly with issues of copyright-related offenses. But by implication, every offense under this copyright law, all you need to do is to go to High Court straight to file your cases. So that if you need to seek an injunction, if you need to intercept a document or things that are of your own, and somebody has dubiously made them and trying to ship them abroad. Let's say, for example, you have taken a very nice picture, and then that picture somebody has printed plenty, and he's taking it to abroad to go and sell. You have every right to make sure you contact CEPT to intercept it at the port, either airport or the harbor, so that the infringement cannot continue. So these are some of the reasons of how you can tackle infringement and how remedies you can seek. And so let me come to in-house studio and see if they have questions for me. And those in the audience too, please, if you have a question, kindly go to the microphone and then you can ask your question. So let me hear someone who has a question.
Let me ask one question.
Yeah.
So you mentioned that when a corporate body, let's say a company, and they infringes on someone's copyright, the directors all get penalized.
Yes.
If, let's say, the company is a limited liability company, why not just penalize the company? But how does it usually work? Does every director get to pay a fine?
Okay, so it is deemed that all the directors have committed the offense. So you are charging the company. And if the company doesn't have money, it's the directors who will pay for it. And if they don't have the money and somebody has to go to prison for it, then it's the directors that are supposed to go to prison. If it is the partnership, like a company partnership, and it's the partners that's supposed to go to prison, because copyright has criminal and civil. And the criminal is that you go to a summary, you get a summary conviction to go to prison for 3 years. So company cannot go to prison. It's the directors who are the company or the partners in the company that are people supposed to go to prison. And so that is what it means.
Okay, so to the best of my knowledge, I know that these laws are they have been in existence for more than 10 years now. And it's still the same story we hear each day in and in day out, because people still complain that their works are being sampled. Some say there's copyright infringement. Is it that the laws are not working, or just that the laws are being too flexible?
Okay, thank you very much. You see, like I always keep on saying, copyright is a personal, private property. The laws are there. You have to make sure that you fight for it. For example, it's like you wake up and your toothbrush has been stolen. You go to court, you let go, right? Or you have a blade, a used blade, and you left it there. And then somebody came, you are seeing the person. He's trying to steal your blade and he stole it. And then you decide to let it go, right? That is your choice. It's the same with copyright. I don't think you wake up one morning and your car, somebody is actually breaking into your car and you are looking at the person. And the person managed to break the glass, enters and connect wires and started driving away. And you still stay and watch. You will not. So the laws are there for you to know that there is a law to protect you. But as to the enforcement and making sure that the law works for you, it is your decision, not any government agency. Not even the police can be stopping people's cars on the road. In fact, did you steal this car? Or this phone, did you steal it or you bought it? The police have no right to do that. So if a song is being used for an advert, nobody can go and ask anybody that this song, this advert, the songs in it, have they been copyrighted or has the owners been notified? No. So we need to understand this from this point because that has been the main issue. Some people think that the Copyright Office should protect their works. No, Copyright Office don't protect their works. Like I read in their functions, they are to maintain and register. They are to make sure that if there are disputes and you approach them, they can be able to give you guidance and counseling. But as to protect your work, please, it lies within your own self. Is there an artist or a film person, artistic craft, whatever person you are within the copyright domain? Yes, more questions?
Yeah, so to the person who is out there and is wondering the case of copyright and fair use, understand libraries can use copyright works and get away with it. But are there other institutions or bodies that can tap into fair use? What are like the clear distinctions?
Okay, so it's not like libraries can use and get away with it. Okay, when you say it that way, then you are saying that they are doing something wrong and the law says no. The law says that library can make copies of a work and keep in the library. It is not something they are doing something wrong. No, that is what the law has established. So they can do that. The same law says that an individual, you can download somebody's song and use it privately at home. And it's okay. It's not that you download and you use it at home and then you get away with it. No. I want you to let your statements be in such a way that you are not implicating anybody. Okay? So the libraries are not doing something that they are getting away with it. No.
Like they are permitted.
Yes.
So it's like, you do it and you are allowed. Like you are permitted to get with it.
Exactly. You are allowed to do that. But an individual, you are not allowed to make somebody's whole book completed. Institutions like education, whether kindergarten or to university, they are allowed to use materials for teachings. So I can go to a class, a nursery, or what, and play Kwame Eugene's song, Shatawale's song, Daddy Nubel's song, Nana Pedu's song, Ebo Taylor's song, Jayana's song, anybody's song for the class, for purpose of education, right? For that. And it's okay. But I can't go and make a copy and come and distribute to the children. Well, listen, no, that is not educational purposes. For teaching, for learning purposes in the classroom, they can do that. Yes, say your question.
Yeah, so when it comes to fair use, right, I want to understand, I want to believe there are instances where you can take somebody's copyright work and use a little amount of it and not really copyright infringe. Like, for instance, if I want to critique someone's work, like let's say a film, a song, and I want to critique it, am I allowed to use like just a little bit of it?
Okay, right. So for critique in a classroom setting, you can do so. But not for critique and you come and sit on social media and you are playing somebody's video for 1 second or 5 seconds and you say you are critiquing it for free. No. Do you understand? You see, critique, all those things are, there is a way to go about it. One, if they have a trailer version online, you can use the trailer to talk about it. It's okay. It's permitted. That's a trailer. But to sit where it is not part of the trailer and then you capture 2 minutes, Okay, let's watch. And then after you watch, now, if you do those things and you are doing it on YouTube, by the time you finish, your video will be muted. Yeah. And these are not my decision. It is international copyright law, which YouTube and Facebook is trying to make sure that they make sure that the law works. Let's take, for example, Instagram. If you do somebody's songs on Instagram or TikTok and you are playing somebody's songs in it, before you finish, sometimes they will say, no, we will not allow you to use our songs for your program on TikTok. So before you finish, they mute your video and the sound is gone. You cannot get it back. YouTube and Facebook, or they do so.
Okay, so let's say if it's a music video, for instance, and I want to critique it, if I know my sound will get muted, can I go ahead and just use the visuals and, like review? Because for music, they don't really do trailers. You would agree?
Yeah, they do. They do.
Trailers.
Oh, yes. Go to Audio Mark. They play it. They say, oh, this is my song. Please, Amazon as well too. This is my song. Please listen. And then they will tell you, okay, now back to your original song during the advert period. So what those are trailers? No, that is what we mean by
so I mean like music video, because on Audio Mark it's audio.
Yes.
So you may not be privileged to hear that advert.
Okay.
And let's say a music video too, you may go on the artist channel and you may not see an exclusive trailer for the music video. But let's say the person is famous, right? And you still want to talk about it.
Yeah.
Is the best thing to do to mute the sound and use the visuals a little bit, or not to try at all?
Both all may institute an infringement. Okay? If the person allows you, let me say that you go to one of the artists we know in Ghana and you tell them that you want to critique their songs. You notify them and it gives you the go-ahead. You can play the whole video. They will be notified and they will say, leave the person. Okay? So this is what it's not like I have the say and I'm telling you. It's what the law states. So we don't have to read meanings into it so that you go do it and you say, Bnoskka said this and then my song has been muted. No. Notify the right owner if he gives you the go-ahead to do so. After all, tell me, if you don't critique that song or that video, what will happen? Nothing.
Nothing will happen. But
Exactly. So you want to critique it to create a content. Is that not right? You want to critique it to create a content. Let's assume if you want to critique it at home and you are not showing it on Facebook, you are not showing it on YouTube. Of course, you can watch the whole video even 10 times and critique it at home. And that's it. But once you want to do that onto another medium, like we spoke on one of our episodes about program carrying signals, broadcasting. You also broadcasting somebody's content. You are rebroadcasting. You are adapting it. You are translating it to another medium. Then you need authorization to do so. If you do it and nobody say anything, that's okay for you. For example, permitted use of works are libraries, newspapers, dictionaries, encyclopedias, government enactments, like the Copyright Act that we are reading here. All these ones, you can use them for critique or whatever, and nobody will say anything. Okay? Yes. So, and public works, such as parliament sittings, they are hazard, they are those things. If you have a copy and you are critiquing, you are reading about it, there's nothing, because the laws permit those ones. But for somebody's individual work, and you say, I want to play this song and critique it, go and ask for permission, right? So I know some people are doing it and nobody is saying anything, right? But it doesn't mean that that is the right thing. Why is it that then BBC will say, oh, let's critique Michael Jackson's song. Then they'll play the song and then they'll critique it. Can you imagine? It's a big issue because you have to pay copyright royalties on it. And if you want to avoid that, you see, things are not working well. That is why we think some of these things happening are okay, but they are not okay. Any question from the audience? Let me go to the audience.
Okay, so my name is Clement.
Yes, Clement.
My question is, those who upload their works under the Creative Commons,
Yeah.
can an individual download it and, let's say, use it commercially, unit sound or video?
Good. So the Creative Commons systems are all under Universal Copyright Conventions. Once you accept that you are uploading your songs under Creative Commons, then it means you waive your economic rights over it. So anybody can also pick it and use it anyway, anyhow, but your name will still be there. Sometimes your name even gets missing in the system. Like, people don't even remember who did the first one. People don't know who did the first one, but then it keeps going. So Creative Commons, the moment you agree to the terms and conditions, you have waived your economic rights. You will have no rights. You can commercialize it. If somebody is also commercializing it, you cannot talk. Why? Because you have waived your right. When we say waived your right, it simply means that you have transferred your economic rights onto the general public or the public domain. So that is what it means. And this one, if you find a case in it, I can confidently tell you that you will lose that battle because you have agreed to Creative Commons. Any questions?
So with that, let's say there are like multiple platforms. There's, license, like there's a YouTube, there's something else. If you upload a video on YouTube and you select the Creative Commons and on another platform you maintain your rights, does it become a conflict?
No, it will not become a conflict, and it will not even work on the other commercial platform you are using, because once you upload your music on YouTube, there's something that is created automatically for you. We call it Digital Content ID. And that Digital Content ID will now trace everywhere that song goes. So the Creative Commons you have selected work on any other platform. So you cannot go and put it on another platform and decide that here I'm going to commercialize it. No, it's gone.
Okay. I'm also curious, what is the best form of authorization in terms of infringement? So let's say my colleague here, Sami, has work, and I go to him, I'm like, I want to critique it. Can I use a part of it? And he says yes. Should I get him to handwrite it? Should I get him to email it? Or is there like a special form that I need him to fill?
Okay, so whichever means you want to use to get the right authorization, I would encourage you to do the best means. Earlier on, I spoke about writing, because the writing will require that somebody testify. And like you said, email is very fantastic. You wrote it, and if you are sure that the email you received is coming from the right person, then you have your say to go. But in all cases, don't forget, somebody, even after getting the right, somebody can still send you to court, and the court will listen and be able to determine whether there is an infringement or not. Right? Any question?
Okay, so the part where the law stated that as part of the penalties that it's right or it's fair enough to take the devices these people are using for the copyright implement. Yeah, okay. So does it just end there, or there are other further steps or measures that have been taken?
So once your devices that you are using and they are infringing, and the copyright of police comes to impound on them, it gets to court. Sometimes they can auction them to defray the cost. You have infringed somebody's right, so they will auction them and to get the money to compensate the right owner. Okay, and then sometimes too, after auctioning, if the money is still not enough, they can go and take your house or your car, seize it, that you have caused this infringement and you have to pay this damage to this person. And the things we seized are not enough. So they tackle your house or your car or any property you have. They will sell it to defray the cost. And if still, you are to also to go to prison. Like we said, the infringement can say that you get a summary conviction, to pay a fine, at the same time to go to prison. You will pay all the fines and still go to prison together. Yeah.
What's the last question?
Do.
Can I be held liable for unintentionally infringing someone's copyright?
Unfortunately, there's nothing like unintentional, because infringement is an infringement, whether you intended it or not. You remember in our acts, there are our Criminal Offences Act, what people say the Criminal Code, Act 29. There is ignorance of the law is no excuse. Yeah. So you cannot say that, oh, unintentionally I infringe. How is unintentional unintentional?
If I can prove that,
No,
sincerely,
I'm sorry. I don't want to confirm that statement. So that somebody watching will say, Bnoskka confirmed that unintentionally I can infringe on somebody's right. No. If you know the right thing, do. If you don't know the right thing, then make sure that you also you observe the right of other right owners. So let's try as much as possible to make sure that we respect the offenses that we have read. We read it further. Pick any copyright act all over the world, and you can be able to familiarize yourself with the offenses. Stay safe. Have a wonderful day. This is Bnoskka. I am telling you.